Floor is yours.
Thank you. Good evening, Chairman and members of the committee. My name is Sarah Hunt-Blackwell. I'm the First Amendment policy advocate with the ACLU of Georgia. The ACLU of Georgia opposes SB 180, not because we oppose religious freedom, but because we support it. This committee is no stranger to the First Amendment. As you all know, part of the First Amendment enshrines our core rights to exercise religion without undue government burden and to live under governments that do not adopt any particular religion. These elements together, the Free Exercise Clause and Establishment Clause, are vital to proper religious protection. We receive the fullest extent of the protection when these rights are afforded in tandem. To be clear, the federal RFRA bill, which passed in the 1990s, included provisions addressing both religious freedom clauses. But SB 180 only adopts language related to the Free Exercise Clause, but not the Establishment Clause. As such, SB 180 is not an exact mirror of federal RFRA. Even the Illinois version of RFRA that was referenced earlier included mention of the Establishment Clause. Omitting the Establishment Clause could easily advance restrictive and extremist policies that discriminate against LGBTQ+ communities and others with whom religious extremists disagree. SB 180 emphasizes the compelling interest balancing test as if it's a surefire protection against discrimination risks. I proffer that the government indeed has a compelling interest in protecting the rights of LGBTQ+ people who could otherwise be discriminated against under the guise of religious freedom. In that regard, this balancing test is already partly satisfied. The Establishment Clause is not optional. It is quite literally written into the fabric of our country's Constitution. The text verbatim says that the government, quote, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In Kennedy versus Bremerton, the Supreme Court's most recent decision dealing with free exercise and government establishment, the court specifically says that these clauses have, quote, complementary purposes, not warring ones. If we are going to codify this in Georgia law, let's make sure that we codify the full protections, not just the half-baked version that creates a license for discrimination. Please either modify this bill to include anti-establishment protections or vote it down in its current form. Thank you.
All right, thank you, Ms. Blackwell. You do have a question from the committee, Senator Parent? Yeah, U7.
Thank you, Mr. Chairman. Thank you, Ms. Blackwell. I don't have the text of the federal RFRA in front of me, I don't believe. Do you have specific language or areas of this bill where you're telling us that it differs?
Yes. So in the federal RFRA it starts with the Free Exercise Clause, and then in the lower half of it, it also has language against government establishment of religion as well. Both clauses are included in federal RFRA. And even in the Illinois version, admittedly, there's not a specific Establishment Clause section, but there's an exemption at the end of that bill that says that nothing in that bill should be used to infringe upon establishment protections. So even in that form, there's the Illinois RFRA still at least loosely mentioned the Establishment Clause, whereas SB 180 does not mention it at all.
And it seemed from your testimony that your primary concern is about, and I know that we started to see this renewed push for state level RFRAs after the decision on Obergefell at the U.S. Supreme Court legalizing gay marriage. Is it your opinion that LGBT groups are the most impacted these days by state level RFRA? Is that the group you're primarily concerned about?
Primarily, yes, but I think that it could have some other far-reaching implications as well. We've kind of seen this play out already in some Supreme Court cases, well, in the Supreme Court case specifically, where there was a service provider who did not extend their service to a gay couple because they said that it was their religious right to do so. And unfortunately, the Supreme Court upheld that decision. That's not a decision that we agree with, and that is one of the dangers that we are seeing associated that could come from a RFRA bill that does not include an anti-establishment clause. Thank you. Thank you.
All right, no other questions from the committee. Thank you.